on YouTube to see. And she was like, wait, what?
It is.
Yeah, like our real board is on YouTube. And she was like, give me the name. You better press the like.
Before was up here, I used to watch the
They actually comment.
That's really me. Just go in there. I text my wife and say,
The first time is like,
I don't know about you sometimes.
all right, Ms. Tabraham, I am ready. You just let me know when you're ready.
Okay, we are ready on Ms. Beasley and Anthony Clifton.
All right, court call CR 17-357, CR 21-161, State versus Anthony Wayne Clifton. Are we pleading out Mr. Clifton on the stalking case?
Your Honor, I believe Ms. Heisel has an announcement.
Okay, Ms. Heisel, take it away.
I am trying, Judge. Oh, there it goes. Yes, Judge, the state is requesting that we reset this plea, that we have Mr. Clinton enter a waiver of jury trial to the newly indicted charge today and reset for 30 days. We have some victim concerns that we have to resolve before we enter.
Does Mr. Clifton have the waiver of jury trial on, and I presume that's CR 21-161, the unlawful possession of firearm by felon?
Yes, sir. He signed it today. It's filled out and signed.
All right, Mr. Clifton, if you'll raise your right hand, I'm going to place you under oath. Mr. Clifton, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, I do.
Okay, you put your hand down. All right, Mr. Clifton, understand that you have the right to have your case tried before a jury of your peers. You have the right to cross-examine and confront the state's witnesses and the evidence they seek to bring against you in front of a jury of your peers. And that right to trial by jury cannot be taken away from you, as it is guaranteed to you under the United States Constitution and the Texas Constitution. However, you may waive that right if you do so of your own free will, intentionally, knowingly, and voluntarily. Is that what you're wanting to do in this case?
Yes, sir.
You understand if you waive your right to a jury in cause number CR 21-161, wherein you're charged by indictment with the third-degree felony offense of unlawful possession of firearm by felon, that right may not be restored to you, but only under very limited circumstances.
Yes, sir. Yes.
All right, Ms. Beasley, you join in with your client requesting the court to allow him to waive his right to trial by jury?
I do, Your Honor.
And is that a waiver of trial by jury in each cause or just the firearm charge?
On the firearm charge, Judge, there's a motion to revoke.
Okay. Okay. All right, then the court will find that Mr. Anthony Clifton has been admonished of his rights to trial by jury. Court finds that he's intentionally, knowingly, and voluntarily waiving those rights and is joined by counsel for the defendant and also counsel for the state in open court. And the court approves that and will sign that order granting that waiver. Court will reset upon the request of the state and the defense to, how long do you think you need, Ms. Heisel?
We would have 30 days. We do have an agreement already.
Ms. Beasley, are you available on the 27th, July 27th?
I am, Judge.
Okay.
Yes, sir.
We'll set Mr. Clifton then for a plea in CR 17357. And are we setting the plea on the firearm same day?
Well, both of them will be resolved with the same.
Ms. Beasley, do you know, has Mr. Clifton been arraigned? My docket says we're set for arraignment and plea today on the firearm charge. Has he been before the court and been arraigned?
I do not believe so, Judge.
Do you, you don't by chance have a waiver of arraignment form with you, do you?
I do not, Judge.
Ms. Abraham, do you have any waivers out there?
She's checking, Your Honor.
Thank you.
That plea gonna be at 1:30?
Yes, ma'am. It's okay, Patty. I can, we'll just arraign him now.
You want me to start, Judge?
Yes, ma'am. Do you have the indictment with you?
Yes, sir, we've already gone over it.
Okay, go ahead.
My client's name is Anthony Clifton. He is charged with unlawful possession of a firearm by a felon. He understands the punishment range, wishes to enter a plea of not guilty at this time.
All right, court finds Mr. Clifton has waived the formal requirements of arraignment, and the court will enter his plea of not guilty into the record and set for plea on July 27th at 1:30.
May he be excused, Your Honor?
Yes, ma'am. Thank you, Mr. Clifton. Who's next?
Okay, Judge, we're ready on Mr. Warner with Jeff Wood for a plea.
All right, court calls CR 19-124, 125, and CR 21-196. State versus Jeffrey Lynn Warner. Mr. Warner, if you'll raise your right hand, I'm going to place you under oath. Mr. Warner, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand
I
down.
do.
All right, thank you, sir. And do we have the terms of the plea agreement?
Justice, state have that, or you want it from me?
State just brought it to me.
That for reference, take him copies of all those to the jail. The jail one is the one that will have all the signatures, all on it, it's back here, but
Okay. So are we only going forward in CR 19-124?
Judge, they're going to be dismissing CR 19-125. So the only case that we're going forward on, obviously, we're pleading guilty to the lesser included of arson of a vehicle in 00124.
All right, Mr. Warner, are you a United States citizen?
Yes, sir.
Do you read, write, speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Wood. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed that you do not understand?
I understand it all, sir.
Okay. Mr. Wood, do you believe Mr. Warner to be competent today?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
I have.
All right, I see here that the proposed plea agreement is that Mr. Warner will be pleading guilty to a second-degree felony offense of arson of a vehicle, with the recommendation on sentencing being 4 years confinement in the Texas Department of Criminal Justice, a $1,000 fine, with the state asking the court to consider several cases in this disposition. Is there any restitution in this?
No, there is no restitution, Your Honor. In fact, we've got an affidavit of non-prosecution from the individual's home that was their vehicle that was burned, but there is no restitution that's owed.
No restitution owed to the victim or the insurance company or anybody? None?
No.
Okay, Mr. Warner, a second-degree felony offense of arson of vehicle carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Understanding the plea agreement in this case and the range of punishment, how do you plead to that offense?
Guilty, sir.
Are you pleading guilty because you are guilty of committing that offense and for no other reason?
Yes, sir.
Has
I
anyone
am.
threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. Wood, any objection to states one?
No objection, Your Honor.
All right, states one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
And so Mr. Wood referenced that there was an affidavit of non-prosecution from the victim in this case. Is that correct?
Judge, I am looking currently, this was. This is Drew's case. I can check that. It doesn't give a impact statement that was returned.
Mr. Wood, did you hear Ms. Heisel's statement?
I can't hear her, Your Honor.
She asked the court to recall the case. She wants to check with her victim's coordinator. She's concerned that there is a victim impact statement that she feels needs to be presented to the court, but she wants to make sure of that before we proceed.
Okay.
All right, so go ahead and have a seat, Mr. Warner, and I'll call you back up in just a moment.
Any questions? Yeah, you're here. Sit right here, ask them if they have any questions.
All right, Mr. Wood and Mr. Warner. All right, go ahead, Ms. Heisel.
Sorry, Judge, our system, when we switched over to the new system, it created a notation to make the
Your Honor, Judge, we still can't hear her out here.
Yeah, we got batteries.
Take this one here from defense counsel table, or you can move closer. You can stand up here if you want.
You guys hear me okay on this one?
Oh, she's gonna bust into song, Judge.
Can you hear her?
You guys hear me on this one?
I'm gonna take that as a no.
It is on. Can you hear me if I move forward like this?
Yeah, that's better. That's good.
Okay, Judge, we reviewed the file, the notification was misleading, there is not a victim impact statement on top of here, there is an affidavit and non-prosecution, and although the insurance company did file a restitution request with us, Ms. Curry did not include that as part of the plea agreement today.
Any reason?
I didn't ask Judge, she just said that the state was gonna be waiving restitution for the plea.
Mr. Wood, I questioned the state on the insurance claim that's included in the stipulation of evidence. Wherein the insurance company paid out close to $200,000 for the damage in this arson. And so you heard Ms. Eisel's response?
That's correct, Judge. That's our understanding, is that wasn't gonna be part of this negotiations or part of this plea agreement. I think, quite honestly, there's probably a number of different reasons for that, but yeah, that was never addressed.
And so as I perused State's Exhibit 1, was a vehicle burned for $191,000 or was it a home?
Yeah, Judge, that was one of the problems with the case initially, is it's a party offense. Mr. Warner was a party to the offense. He wasn't actually the one that set the fire, but the fire started in a 18-wheeler trailer. And somehow or another, and I think that's where maybe the contention maybe lies a little bit, but the fire got out of control for some reason and spread to the home, and I think burned some of the home. But the fire initially started in the motor vehicle, or in the 18-wheeler trailer is actually where the fire was started at.
So understanding that Mr. Warner has taken a sentence in another jurisdiction, what was the offense in that case, and what is the sentence?
Judge, Mr. Wood would be able to tell you exactly, it was very similar, I believe.
That was a drug case, Judge. It offer was Mr. Warner pled for 5 years in that case.
And are the victims in this arson case Mr. Warner's parents?
I believe they're related to it.
They are.
Yeah.
I believe it's his mother and his boyfriend.
Mr. Wood, can you direct me to that portion of States 1 that talks about the fire being set in the 18-wheeler?
Judge, you're not probably going to find it in there because it's not in discovery. I had to provide it to the state, which I did so in an email. But then also, it is located in the discovery
I am reviewing the second custodial interview of Charlie Heron, and there is a mention of in paragraph or section 3, subsection 4, it says Warner also gave him some tips on how he would do it and told him to put the lawnmower inside the trailer so that it would burn as well.
Judge, I'll just put it on the record here. It's from the Van Zandt County Fire Marshals. I provided this to the state. It's dated, I want to say September 2018. It says reporting officer was dispatched to 3899 Van Zandt County Road in 1910 Fruitville, Texas, in reference to a structure fire. After arriving at the location, reporting officers observed Fruitville, Edgewood, Wills Point, Grand Saline Fire Departments performing fire suppression. Upon reporting of the officer's arrival, officer observed an 18-wheeler box trailer and a frame house on fire. Reporting officer met with the reporting person identified as Cody Warner, who stated that he was notified by a neighbor that his grandmother's storage trailer and home was on fire. Warner stated that his grandmother, identified as Lucille Warner, was out of town on vacation. It appears that the origin of the fire was the storage trailer, which received heavy damage. The home also received heavy to moderate damage. The cause of the fire is under investigation at this time. And that was from the James Lehman with the Van Zandt County Fire Marshal's Office. And that's also corroborated within the offense report as well, Judge. I just don't know exactly where it is. It's not that apparent, but it's there.
All right, I'm gonna recall this case, and I'll just go ahead and give an indication that I don't think I would accept. I'll just tell you now, I'm not going to accept a 4-year plea bargain on this case after reading the evidence. So I'll recall it here in a few minutes, and I'll let counsel try to persuade me otherwise. But right now, I don't think it's in the interest of justice for 4 years for this case, considering Mr. Warner's involvement in criminal history and the amount of damage that was done to the home and the amount of money that's been paid out in restitution to Mr. Warner's family. So I'll recall this case in a moment. Okay, that'd be good. Mr. Wood, you ready on anyone else?
Yeah, Kronberger's ready, Judge.
All right, court call CR 2395, CR 2124, State versus Brian Scott Kronberger. You got the picture for us on Kronberger. All right, Mr. Kronberger, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? I can't hear you.
I do.
Okay, put your hand down. You're gonna have to speak up. I think that there's some internet issues between here and the jail, so video's kind of spotty and the audio's not very good, but it's important that you speak up loudly and clearly so we can make a record here in the courthouse. This is cause number CR 2395 and CR 2124. Are you Brian Scott Kronberger?
I am.
Do you read, write, and speak English?
I do.
Have you ever been diagnosed with any type of mental condition?
No, sir.
Say again.
No, sir.
And in this case, you are represented by your attorney, Mr. Jeff Wood. Are you pleased with his representation of you?
I am.
And do you feel like you've had enough time to discuss both your cases with him and have all your legal questions answered?
Yes, sir.
Mr. Wood, do you believe Mr. Kronberger to be competent today?
I do, Your Honor.
You've explained to him his legal and constitutional rights.
I have.
All right, Mr. Kronberger, it appears in CR 2395, you appeared before the court. Back here. Oh, no, these are both, they're both new cases. All right, Mr.
Judge,
Kronberger.
I want to make sure, Judge, that you have the 8-year judgment in front of you, not the 12-year.
No, sir, I have 12 years on both.
That's changed, Judge, to 8 years, and we've got new judgments. I've got them over here at the jail, so I don't know how we want to get them over there to you, but that's the difference is everything else the same except for the fact it's 8 years instead of 12 years.
Judge, that is the state's understanding as well.
Okay,
We did originally pick work for 12, Mr. Wood, provided us some additional information, we dropped the other 8 years. We are receiving information.
and everything else is the same?
Everything else should be the same. State is abandoning our enhancement paragraphs to get it that.
Okay, so my judgment says that he's going to plead true to both enhancement paragraphs. That's not true. Is he going to plead to any of them?
Judge, if we want, both we're, it's 3rd degree and 2nd degree, I believe. We would stay with abandon all the Mr. Ward, make sure that they, the judgments reflect that we are abandoning enhancements.
Did you hear that, Mr. Wood?
I can't hear him very good, Judge.
He said that he wants you to ensure that the judgments do not show a plea of true on either case, that the state's going to abandon all enhancement paragraphs. So if there's anything that says true on there, we're going to need to get that redone.
No, both these judgments those are left blank, and then in the terms of the plea bargain, it's indicated that both the enhancement paragraphs will be abandoned.
Okay. All right, Mr. Kronberger, you are charged with a 2nd-degree felony offense of unlawful. Actually, that's going to be a 3rd-degree felony offense. Mr. Kronberger, you're charged with a 3rd-degree felony offense of unlawful possession of firearm by felon, and also possession of a controlled substance in penalty group 1 greater than or equal to well, I got a question. I mean, is this not a 2nd degree?
It should be a 2nd degree.
Well, it says 3rd degree. It says 3rd degree RFO. This one should say third. This one should say 3rd, and this one should say 2nd. So
Yes,
they're,
Judge.
so they're backwards on these.
On those, Mr. Wood, would you check and make sure that the degrees are correct? The
Yeah,
possession,
they're correct.
2nd degree.
They're
and the-
correct on our judges. They're correct on our judges.
Ms. Abney corrected these subsequently, Judge. I'm sure she caught those mistakes in the corrected version.
All right, Mr. Kronberg, I'm going to start over because the record's not very good right now. In CR 2395, you are charged with a 3rd-degree felony offense of unlawful possession of firearm by felon. In cause number CR 2124, you are charged by indictment with a 2nd-degree felony offense of possession of controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams. A 3rd-degree felony offense carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC and a $10,000 fine. And a 2nd-degree felony carries a range of punishment of not less than 2 years or more than 20 years confinement in TDC, that is the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand the range of punishment in each charge?
I understand.
And you're asking the court to approve the plea agreement in each case that you've reviewed and signed with your attorney today?
Yes, Your Honor.
All right, understanding the terms of the plea agreement and the range of punishment for the charges, how do you plead to unlawful possession of firearm by a felon?
Guilty.
How do you plead to possession of a controlled substance, penalty group 1, greater than or equal to 4 grams, less than 200 grams?
Guilty.
Mr. Kronberger, are you pleading guilty in each one of these cases because you are guilty of committing these offenses?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
All right, court will accept the defendant's plea of guilt at this time. Mr. Wood, any objection to states 1 in each cause?
No objection.
All right, states 1 is admitted into evidence in each cause respectively, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right, I'm going to review the evidence. All right, Mr. Woodwhack, I don't have any of the stipulation. I don't have the stipulation of evidence, so I'm going to need you to, I've got the indictment, but can you tell me about the facts supporting these, please?
Yes, Judge. Give me a moment, and I'll bring up this. Judge, on the date in question, the defendant and his co-defendant are called in on as a suspicious persons. They've passed out in the reporting person's driveway. The co-defendant tells the officer that she was driving from Dallas to Louisiana to repossess a vehicle. And they took 6 hours to get from Dallas to Van Zandt County. And she got sleepy and started driving on the back roads. Found an abandoned house that they thought was interesting and wanted to buy. So they go to the reporting person's house. But before she can get to the front door, she passes out, basically with the door open, just like halfway out. Police respond to the house. Mr. Kronberger and his co-defendant are still in the vehicle. They show signs of a lot of criminal activity. They search the vehicle. They find 2 guns. Both defendant and co-defendant are previously convicted felon, and a large amount of meth, approximately 6.2 grams. Owner of the car lot says that they gave the defendants a car to go repossess a different vehicle, but it's not the one that they are in. I think both the guns and the methamphetamine was found in the back seat or trunk area of the vehicle. And both are heavily intoxicated, what appears to be methamphetamine.
Mr. Wood, any objection to that summary?
No objection, Your Honor.
All right, then based on the evidence, the court will find there is sufficient evidence to convict Brian Scott Kronberger of each one of these offenses. Court convicts him of unlawful possession of firearm by a felon, 3rd-degree felony, assesses his punishment at 8 years confinement, and the Texas Department of Criminal Justice assesses a $1,500 fine. Court takes into consideration or finds that the DA's office has taken under consideration unindicted fraudulent use or possession of identifying information in DA 2020-1059, DA 2020-1061, possession of dangerous drug, theft of property greater than 100, less than 750, DA 2020-1060, and unlawful carrying of a weapon, DA 2020-1062. Court orders the weapon seized in this offense to be forfeited to the seizing agency and/or state of Texas. Court orders him to pay court costs of $290 and reimbursement fees of $20. In the drug case, the court convicts Mr. Kronberger of the second-degree felony offense of possession of a controlled substance. Court assesses his punishment pursuant to the plea agreement at 8 years confinement in TDC, assesses a $1,500 fine, assesses $290 court cost and $20 reimbursement fees. The court awards Mr. Kronberger 229 days credit towards his sentence in each case for the time that he has spent in jail on this cause.
Judge, on that note, that initially, I think there's about 2 weeks more than the 229 days indicated on the judgment. This case was set about 2 weeks ago for a plea, and something came up where we could not do it. Everything else in the judgment changed except for that part. So I think the jail would have the appropriate number of days, but I don't know if there's anybody here that can tell me what that is at the moment, but it is going to be more than 229 days.
All right, we're gonna have to have that correct on this judgment before I'm able to sign it or award it. This is what was presented to me by the DA's office. So go ahead and have a seat, Mr. Kronberger, and I'll have to call you back up.
What are the current jail credit reflects?
The judgment say 229 days.
And I think the judgment, I don't know if you could hear, but I think we figured out over here now it's 260 days.
The DA's office is gonna have to certify that. Tell me whether they agree or don't agree. So go ahead and have a seat, Mr. Kronberger. I have to call you back up. We have someone else that's ready?
No, sir, we're fixing to bring the two females up for Miss Beasley.
Okay.
I have one
Stretch your legs. Mr. Abraham, do we have anyone else that's available?
Judge Beasley's, I'm Judge Beasley. Ms. Beasley's ready with Ms. Perry and Ms. Rodriguez.
All right, thank you. All right, CR 19-225, Shelby Lynn Perry. Is Ms. Perry going to be a plea? All right, the state has submitted a motion to withdraw the state's motion to adjudicate guilt and to extend the community supervision for 2 years with Safe P, substance abuse felony punishment facility as a condition of community supervision. And the paperwork also includes the new attorney fees, correct?
Yes, Your Honor.
Okay.
They do.
All right. Ms. Perry, will you raise your right hand? Ms. Perry, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am. Yes, sir.
All right, you put your hand down. All right, Ms. Perry, so you're asking the court to extend your community supervision, continue you, extend you, and you want to go to drug rehab, is that right?
Yes, sir.
And is that a decision that you've made voluntarily? Has anyone threatened, forced, or pressured you to make any of those decisions today?
No, I need that. I need it.
Okay. And so I can trust that with you saying that you need it, that if I send you over there, you're not going to take up a bed and not apply yourself and not take it seriously and try to take advantage of the resources that are being provided to you?
No, sir.
Okay.
She's also
All right.
doing that, Judge, as a support of her family. Her family is behind her and understands how important this is.
Yes, sir.
All right. Thank you, Ms. Beasley. All right, Ms. Perry, if this is the time to get help, if you want help, and you can get it at no cost to you other than your time and your liberty. So I will grant and approve the state's motion to withdraw the motion to adjudicate your guilt. I will extend your community supervision for a period of 2 years in your order to successfully attend and complete the Safe P unit. And I don't want to say good luck because it's not about luck. It's really not. It's about effort. It's about effort and hard work and commitment. That's what it's about. So I want you to go and work hard and be dedicated and be committed to making yourself better so that when you get out, you can be a successful member of society and productive and be reunited to your family. Okay.
Okay, thank you.
You're welcome. All right. I'm signing the order today.
And Judge, I handed the amendment of conditions to Ms. Abraham. She has that.
Thank you, Ms. Beasley. All right, Rachel Virginia Ramirez. CR 1941. What are we doing with Ms. Ramirez today?
We're entering a plea, Your Honor.
What are the terms of the plea?
7 months state jail time. She still owes $1,000 on her fines, no restitution, still owes $407.08 on court cost, and she has 104 days back time credit.
Did you say 104 days back time credit?
That is correct, Your Honor.
All right, Mr. Ramirez, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down, make sure you, thank you, yes, yeah, thank you, Ms. Beasley. If you'll speak up loudly, my court reporter needs to be able to hear everything you say so we can take down a record of it, okay? Mr. Ramirez, you appeared before the court on February 12th of 2019 and pled guilty to abandoning and endangering a child with criminal negligence, state jail felony. Court heard the evidence, found that there was enough evidence to convict you of that offense, but the court deferred a finding of guilt and placed you on community supervision for 4 years and also assessed a $1,000 fine. It was during this term of your community supervision that the court filed its motion to adjudicate and motion to revoke your community service. And as you can see here in the motion, they have alleged in 9 separate counts, various ways that they believe you have violated your community supervision. Have you had enough time to review this motion with your attorney, Ms. Debbie Beasley?
Yes, sir.
Like you've had enough time to discuss it with her and have all your legal questions answered?
Yes, sir.
Are you pleased with her representation of you?
Yes, sir.
Have you understood everything that you have read and signed? And wherever your signature is at in the documents, is that your true and correct signature?
Yes, sir.
All right, Ms. Beasley, you believe Ms. Ramirez to be competent today?
Most definitely, Your Honor.
And does she waive the formal reading of the state's motion to adjudicate?
She does, Judge.
And is it
Wishes to enter
her?
a plea.
Go ahead.
She wishes to enter a plea of truth to all the allegations.
Thank you. All right, Ms. Ramirez, then I'm going to ask you as to counts 1 through 9 as alleged in the state's motion to adjudicate and revoke. Are those counts true or not true?
True.
And are you pleading true because each of those allegations is true and for no other reason?
Yes, sir.
All right, court will accept Ms. Ramirez's plea of true. Ms. Beasley, any objection to State's Exhibit A, the defendant's waiver of rights and plea of true?
No, Your Honor.
All right, State's A is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
No, Your Honor.
All right, then based on the evidence before the court, I find that Ms. Ramirez has violated the terms and conditions of her community supervision. Court finds counts 1 through 9 to be true. Court will follow the recommendation of the state and defense. The court hereby revokes Ms. Ramirez's community supervision, adjudicates her guilt, convicts her of the state jail felony offense of abandon or endanger a child with criminal negligence, assesses her punishment at 7 months confinement in the state jail division of TDC, orders her to pay the balance of her financial obligations, and awards her 104 days credit towards her sentence for time that she has spent in jail on this cause. Ms. Ramirez, you're remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Good luck to you. I'm gonna have to go with the bailiff to be fingerprinted.
We already have the fingerprint, Judge.
Oh, excellent. Thank you. Do we have Mr. Ogletree there? Ogletree?
No, sir, we're fixing to go get the next two.
Okay, who's on their way up?
We're gonna bring up Ogletree and Booker.
Ogletree and Booker. Great, thank you.
Ogletree and Booker, please. Two females.
Your
We're good
Honor,
right now. We're good for right now.
Mr. Abraham?
Yes, sir.
Okay, if you bring Mr. Warner back up. All right, we're back on the record, CR 19-124 and CR 19-125 and CR 2196, State versus Jeffrey and Warner. The court, after reviewing the stipulation of evidence that was submitted to support this plea and considering the recommendation from the state of 4 years confinement with dismissing 4 other cases and no restitution, the court is going to reject the plea agreement at this time, and the court will allow Mr. Warner to withdraw his plea of guilty in this matter. And we will set this for jury selection on August 2nd. And I will get with counsel at some point to determine maybe a special setting for Mr. Warner, considering he was on the court's special setting for trial. And he came off of that, and that week went away in July. So I'm not able to take him to trial as we had planned on July 19th. So
Our special set for review here, as far as, and I, at this time, really just made the investment that still.
all right, so we'll just leave him. We'll put him on jury selection for August 2nd, and then I will work with Ms. Abraham, and we'll see if we can't. If we have a civil trial or something that goes away, or we know is going to go away, we may be able to move him into that spot.
For the record, Judge, he was specially set on this matter before I was representing Mr. Warner, so I just wanted to make sure that the court was aware of that. But
Yes,
we'll do that.
Okay, so Ms. Abraham, if you can just make sure there's a special, there's a jury selection setting for him on August 2nd. And then
Yes, sir.
I will take into consideration my conversation with counsel in this case and my review of the evidence, and let the parties know if I'm going to reconsider.
Hey, Judge.
And it's okay to go ahead and send him back to Smith County?
Do we have him here on a bench warrant from Smith County or from TDC?
No, from Smith County. They've
Smith
sent
County.
in his, they've sent in his pen pack, Smith County has. So I don't know when they'll be picking him up, but.
Do we have any kind of obligation under our bench warrant to have him back by a certain date? Do you recall?
No. I mean, I can call over there and make sure.
We'll go ahead and return him to Smith County, and then if they want to process him to TDC, I think with the state of our jail and being at maximum occupancy, we probably don't have that extra room anyway.
Judge, all I know is that there is a hold, Van Zandt County has a hold on Mr. Warner. So I don't know how that affects things. I don't know if Smith County taking back or not regarding that, but.
Yeah, it happens both ways. Sometimes they notify us to come get them. Other times they just ship them to, I'm not just saying Smith County, I'm saying other counties, even with our hold, we'll just ship them off to TDC and we have to go find them and get them. So
I just want to make sure the record's clear that he does have a hold on him right now out of Van Zandt. So it gets time, in other words, Judge, is what I'm talking about.
and I can't confirm whether there's a hold that'll have to be done by the sheriff's department.
All right, we can make sure that that's done then too. And Judge, I know Kronberger, I think we've gotten that resolved with the time.
Do we have an agreement back time?
Yes, Judge. My records reflect
Mr. Kronberger, step on up. Do we have a corrected judgment?
I believe they sent it to the jail judge, just so Mr. Wood could review it.
Is it 260 days?
I believe it's 200, Jeff, correct me if it's wrong. I believe it's 262 days.
That's what I'm showing, Judge, is 262 days of back time.
Okay, then we're back on the record, CR 20395, CR 2124. Court will award Mr. Kronberger 262 days credit time towards his incarceration for time that he has spent in jail on each one of these causes. And as long as that judgment is correct, then I'm going to ask that Mr. Kronberger be printed on those judgments, and the court will sign that upon it being returned. So, Mr. Kronberger, you're remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
I believe that's all I have for this afternoon. I can be excused.
Yes, sir. Thank you, Mr. Wood.
Okay, and Judge, we have Christopher Booker for Ms. Beasley.
This is CR 2105, Christopher Glenn Booker. Motion to revoke. Go ahead, Ms. Beasley.
Your Honor, client has an additional new case. The state sent me a copy of the police report yesterday afternoon, I believe. But I have not reviewed all the discovery yet. We have DVDs. I don't think the DVDs are in the DA's office yet, so I need a reset in order that we can resolve both cases.
Is the new case indicted?
Judge, it is not, it is.
No, sir.
It is a brand new case. It's possession of controlled substance penalty version 1, wait for 200. I got the report from the Rosebud Police Department. We have not been heard an actual case. I requested that with video information. And I think it's one of the main thrusts.
And so we're months out from the lab report, probably.
I have possibly, Judge, I've also had Mr. Crawford contact the lab to see if we can expedite that because it is the basis of it. So hopefully we can expedite that as well, but I don't have any.
All right, court will reset Mr. Booker for the contested docket on September 30th to give the state time to see if we can get the lab report in and for the case to be presented to the grand jury, if that's the decision.
Yes, Judge.
Is that at 9 o'clock, Your Honor?
That's the evidentiary docket. So I'll tell you what, let's set that one at 1:30. I think after today, I may be changing my policy on how we handle bail and jail on evidentiary days and the number of cases we put on evidentiary days. So let's just leave that at 1:30 that day, Ms. Beasley.
Yes, Your Honor. May he be excused, Your Honor?
Yes, yes. Thank you, Mr. Booker. Three available.
Yes, sir.
Have you had an opportunity to look over the indictments with him?
Yes, sir.
Okay, this is cause number CR 21-136 and 182, State versus Philip Andrew Ochiltree, second degree sexual assault of a child. and second-degree aggravated assault with a deadly weapon. Go ahead, Ms. Beasley.
Your Honor, my client, Philip Andrew Ogletree, says his name is spelled correctly in each of the indictments. He understands the punishment range of both of the cases, and he wishes to enter a plea of not guilty to CR 21-00182, as well as not guilty to each and every one of the 3 accounts that's listed in CR 21-00136.
All right, court will find that Mr. Ogletree has waived the formal requirements of arraignment when his plea of not guilty into the record, and we will set this matter for pretrial in August. Give you time to review discovery, Ms. Beasley. Are you available on August 10th or 12th?
Yes, sir. August the 10th.
You prefer that one? All right, we'll set pretrial on August 10th in each case.
May my client and I be excused, Your Honor?
Yes, thank you. Does that just leave us with Mr. Knoll and his clients, Backus, Norris, and Phillips? And,
They're on their way up, Your Honor.
okay.
Okay, our last 3 should be on their way.
Thank you.
You think I'm kidding?
Your Honor.
Yes.
Okay, we're ready on Mr. Knowles 3.
Okay.
Who do you want to start?
Whoever the judge, whatever's easiest. Judge Mr. Norris is here on an arraignment. The other two gentlemen were actually here on arraignment. We have discussed both of their cases already, including reviewed discovery. As opposed to arraignment, we're ready to accept plea agreements on Phillips and Backus.
All right. Here, Ms. Heisel, I think I've got the signed ones on Backus. I think I've got the signed ones on Backus and the signed ones on Phillips. I think. Should I got it here?
You should have, Judge, they were left there this morning.
But I don't know if I have a waiver. You know, these sign on.
Judge, I'm not aware.
Mr. Knoll, did Mr. Harry Milton Phillips Jr. or Junior Phillips, did he sign his waiver of indictment?
Judge, actually, probably about 3 weeks ago, maybe a little more, we thought we were going to plead this case pre-indictment. It was not necessary because they did get the blood work back in time. It got indicted, so we didn't need to sign a waiver of indictment because it did get indicted.
Judgment says information though.
Is there an indictment in the circulation evidence?
Yes.
Okay, then I'll just have the.
Yeah, she'll do that for me. Okay, thank you, Mr. Knoll. All right, go ahead and bring Mr. Let's do Backus up and then DA's office is going to correct the judgment on Philip 20.
Yes, sir. I'm 6'5" and I'm almost 6'9". Yes, sir. 220 pounds. I used to be brought up.
All right, Mr. Backus, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is David Scott Backus, correct?
Yes, sir.
And Mr. Backus, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
PTSD, bipolar depression. Yes, sir.
Are you currently?
Can I speak on that just?
Well, let me finish with him first, and then I'm going to ask you all about that. Mr. Backus, are you currently on any type of medication or undergoing treatment for any of your disorders?
Negative, sir. Not here in the county jail. I was supposed to see the nurse here about that, sir. I was supposed to speak with Miss Lisa, I guess one of the nurse ladies here, and she still hadn't got back with me on that procedure yet, sir.
Do you feel like the fact that you're not on medication or undergoing treatment at this time any way prevents you from rationally understanding the proceedings as they've been occurring in your case?
Negative, sir.
All right. Mr. Kurt Knoll is your attorney. Are you pleased with his representation of you? Are you pleased with Mr.
Yes.
Knoll's representation of you?
Yes, sir. I have all confidence, Mr. Noel, sir. Yes, sir. I sure do.
Good. I'm glad to hear that. Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir. Positive.
All right. Mr. Knoll, do you believe him to be competent today? And this will be your opportunity to discuss the mental health diagnosis.
Judge, if I could on those issues, my client is a Army Ranger. He's a veteran of 2 tours, spent 8 years in the military. I guess platoon would be the appropriate statement that he served with, was called the Lucky 7. However, on one day, only 2 were lucky to some extent. 5 were killed in an explosion, IED. Since that time, his wife of 18 years and daughter were killed by a drunk driver on Interstate 20. The fact that he can stand here at all is surprising. He and I visited about actually those issues brought up very late in the conversation. Sunday, we talked by telephone a few times prior to that. Do I think he needs treatment for his PTSD and the other issues he's mentioned? I do. Do I think he understands what he's doing here today? I do. The fact that he has a prior drug conviction that caused the military and this government to discontinue his benefits is incredible to me. I told him that I would research that issue. There is a law firm that I believe I will consult with him at another date that can help him get those benefits back since he is disabled. We are ready to proceed today.
All right. Thank you, Mr. Knoll. All right, Mr. Backus, you are charged with a state jail felony, which has been enhanced by allegations of prior convictions of the offense of unauthorized use of a vehicle, which, if the enhancement paragraphs are found to be true, would enhance your punishment range enhance your punishment range to confinement in TDC for a period not less than 2 years or more than 20 years, and a fine not to exceed $10,000. I see here that the plea agreement between you and the state is that punishment be assessed at 5 years TDCJ with a $2,500 fine, court costs, and you receiving 102 days credit towards your sentence for time that you spent in jail on this case. Is that your understanding of the plea agreement, Mr. Backus?
Sure. That was what me and my attorney discussed on the visitation day. We agreed to that.
All right, and that's what you're asking the court to approve today?
Yes, sir. I mean, I have no other choice but to, because I have my prior convictions. I don't have to lie to kick it like that, sir. You know, I did commit my crimes in the past, you know, and I was guilty for everything I've done.
Okay.
Nothing make it, hopefully this third time, I get my head right.
Okay. So, Mr. Backus, I'll ask you at this time then, how do you plead to unauthorized use of a vehicle? Guilty or not guilty?
I'll go ahead and plead guilty to it, Your Honor.
And are you pleading guilty?
Stand up for my.
Go ahead.
Go ahead, sir.
No, you go ahead. You were saying
No,
something?
go ahead.
Well, I was going to ask you,
I'll plead guilty.
All right. And are you pleading guilty because, David, you are guilty of committing that offense?
In some category, Your Honor, you know, the way I looked at it, you know, the guy lending me the keys to his car, you know, I did have authorization to use his vehicle. I did have the keys. He handed them to me. He wanted me to go pick up some party girls for us to party with at that motel room that night. And it did occur, you know, that I was late bringing his vehicle back, you know, because it was in Nacogdoches, Texas. It was a couple of hour drive one direction and a couple of hour drive coming back. And he was drinking a lot. You know, there were bottles of liquor found in the vehicle, you know, that didn't belong to me. I don't drink because of my other occasions of the Army. You know, I won't be my same self if I did drink, but it was his liquor. and it was his vehicle, and I was late bringing his ride back, and I can understand why the man was upset with me on why he called the police on me, you know, by me having his vehicle out too long, you know, and that's the reason why I'm here today, you know, and I did get arrested for it, you know, they did impound his vehicle, you know, and he did get it back, and which I'm glad he got his ride back, you know, now I ain't got nothing to worry about with it no more. You know, I'm incarcerated behind it, and here I am facing 5 years in prison because I was bringing somebody's ride back too late. I guess I could say I am guilty on that, you know, that was my fault. I'll never do it again. I'll never borrow nobody else's vehicle again, ever.
Okay. And Mr. Backus, the allegations about your prior convictions, is that true or not true?
Yeah, those are true, sir. I did have a drug problem back in 2011. I want to say it was back in 2009, a year after I got out of the military, and in 2011, I did catch 2 prior drug convictions. They were ran concurrent. That was when I did my first 5 years. That was my first TDC number. I made parole, completed parole successfully. And I turned around and got out. Then I got a check in the mail and I signed it and cashed it. And that was when my forgery of a financial instrument came into play. That was when I got my second 5 years. And that was where other hires come from, my forgery charge. And that's the one I just got off parole on the 2nd of January. And I was coming through Canton first to go leave the state. I'm going to start a new life, but I guess I'm not now for another at least 5 years. But that's
all right,
okay. I'll make it through it.
All right, Mr. Backus, then the court's going to accept your plea of guilt and your plea of true at this time. Mr. Knoll, any objection to states 1?
No, Your Honor.
All right, states 1 is admitted into evidence. The court takes judicial notice of the defendant's plea of guilty and the defendant's plea of true to the enhancement allegations. Is there anything further from the state? From the defense?
No, Your Honor.
All right, I'm gonna take just a moment and review the evidence.
That was a long time ago too. When that happened. I haven't done drugs again since I've been clean. So it gives people that do drugs, they don't do nothing but destroy their lives. So if you can think about it, many years that's been since I lost my benefits, I can get my benefits back. If I hired you to do it.
No, I don't know much about it. That's gonna be a real special thing. But I'm gonna get you the information.
Yes, sir.
All right, court's going to find that there is sufficient evidence to support this plea. The court will follow the plea agreement in this case. Court hereby convicts Mr. David Scott Backus of the state jail felony offense of unauthorized use of a vehicle. Finds that based on the plea of true, that the court does find that it is true on the enhancement paragraph, enhancing the punishment range in this case. Court hereby sentences Mr. Backus in pursuant to the plea agreement in this case to 5 years confinement in the Texas Department of Criminal Justice with a $2,500 fine, $290 court costs, and 102 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Backus, you are hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and the conditions of the sentence. And Mr. Backus has not been fingerprinted yet. Is that correct?
I don't believe so, Your Honor.
Okay, we'll have to bring the judgment over and have him fingerprinted. All right, Mr. Backus, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence, and we'll bring the judgment over and have you fingerprinted later today. Good luck to you, sir. All right, Mr. Knoll, who do you have next? Ready?
We've got a quick, I guess, arraignment on Mr. Norris.
Okay, Mr. Norris, Ricky Truman Norris, CR 20181.
Oh, yeah. Judge, we have received a copy of the indictment in Ricky Truman Norris's case. He has indicated that his name is spelled correctly. He understands the charge against him. For the purposes of arraigning this case, we would enter a plea of not guilty. In a phone conversation with Mr. I'm sorry, Judge, in a phone conversation with Mr. Norris, he does have another charge that I believe is unindicted. We obviously won't be taking that up today, but as far as this case, what we're reading, name is correct and the plea is not guilty.
All right, court will find that Mr. Norris has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record, and we will for pretrial. Do you prefer August 10th or 12th, Mr. Knoll?
It's 12th, Thursday, I guess.
All right, court sets this for August 12th at 1:30. If Mr. Norris makes bail, then it will be at 9 a.m.
Thank you, Judge.
All right, are we ready on Mr. Phillips?
Yes, Your Honor.
I believe we are, Judge.
All right, is this Mr. Phillips?
Yes, sir.
All right, Mr. Phillips, if you'll raise your right hand, I'm going to place you under oath. Mr. Phillips, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
No, sir.
All right, put your hand down. Make sure you speak up loudly and clearly. Mr. Phillips, you are Harry Melton Phillips Jr., correct?
Sorry, I'm deaf in the left ear.
Okay, well, maybe you need, step up to the camera or to the speaker and I'll talk louder. Does that help?
I'm hoping so. It sounds louder, clear.
Is your name Harry Melton Phillips Jr.?
Yes, sir.
And Mr. Phillips, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Kurt Knoll. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you have read and signed that you do not understand?
No, sir.
And where you have signed in the paperwork, is that your true and correct signature? And did you only sign that once you were comfortable that you understood everything that you were reading?
Yes, sir.
Mr. Knoll, do you believe your client to be competent today?
I believe so, Your Honor. Although the case was only recently indicted, Mr. Phillips was actually incarcerated in Kaufman County for about 3.5 months. He and I conversed several times while he was in Kaufman County, and actually there was an intent at one time to proceed pre-indictment. And actually, this is the same plea offer that I received, pre-indictment from State's Counsel.
Judge, I just need to correct the record. If everybody would take note, that is a felony information that was filed in this case. Mr. Knoll is correct that this was a pre-indictment offer. We did then get the labs. However, I did not end up presenting it to the grand jury. So I have emailed Ms. Burns over at the jail a copy of that waiver of indictment, because we do need to execute that. I got a little turned around, Mr. Knoll, on which came first, the chicken or the egg, but I think we're back on track now. It is a felony information, so we do need a waiver of indictment in this cause.
Judge, we're executing that right now. But again, that was something we had discussed actually first week in June, as I recall. In fact, Ms. Abraham also received calls from Mr. Phillips, and he indicated, I believe specifically, the copy of the email is dated June 7th. Mr. Phillips requested that he be allowed to accept the 12-year offer on this case. And we have now executed, and I don't know when the court can see what I'm, we've executed the waiver of
Okay.
indictment.
Okay. All right, so Mr. Phillips, do you understand that you have the right to have your case presented to the grand jury? And that you can waive that right? And that you can waive that right, and by waiving that right, you can allow the state to prosecute you on the filing of what we call an information. And that just means that your case does not go to the grand jury and they do not decide whether or not there's probable cause to believe that you've committed a crime. Is that what you're asking the court to do today, is to allow you to waive your right to an indictment and proceed with being prosecuted on an information?
Yes, sir.
Okay. And are you doing this of your own free will and accord? No one's threatened, forced, or pressured you to make you waive your right to an indictment?
Yes, sir.
Okay, court will approve the waiver of indictment in this case and find that Harry Melton Phillips Jr. has intentionally, knowingly, and voluntarily waived his right to an indictment. And Ms. Abney, I'm gonna apologize to you, but earlier I believed that I was gonna be getting a new judgment. And so I marked out on the judgment that was provided to the court, I marked out indictment and I marked out information and I wrote indictment. So if you would oblige the court, if you could send a new judgment, because this has got to go to TDC, just indicating that the charging instrument is an information, I would appreciate it. I was going to do a swap out with the judgment, but the junior is in the wrong spot.
Judge, I actually have, Mr. Haverham actually had copies of that. I have a copy that I'll bring over when I come with Mr. Watson.
Does his name appear Harry Melton Phillips Jr. or does it say Harry Melton Jr. Phillips? I know the answer to the question. Yeah, so Ms. Abney, if you could get me an indictment that has Junior in the correct place, and are you texting her as
I
well?
am texting her to make sure.
In case she's not watching.
Yes,
I figure she was glued to the YouTube channel.
she typically is, Judge.
All right, so
The waiver of indictment does have Harry Melton Phillips Jr., so we're good with that.
good with that one. All right, so Mr. Phillips, you are charged by information with an offense of driving while intoxicated, third or more, which if the enhancement paragraphs are found to be true, would increase your punishment to that of a second degree felony offense, which would carry a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. What I need to know, Mr. Phillips, is how do you plead to driving while intoxicated, third or more offense?
Guilty, sir.
And Mr. Phillips, how do you plead to the enhancement paragraphs that have been alleged in your case? Are those prior allegations of your prior convictions true or not true?
True, sir.
Thank you, Mr. Phillips. The court will accept your plea of guilt and also your plea of true. Mr. Knoll, any objection to States 1?
No, Your Honor.
All right, State's Exhibit 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, I'm gonna
Judge,
take a
we do
moment.
have actually a fingerprint.
I'm sorry, say again?
We do have a fingerprint on Mr. Phillips already.
Oh, you do? Excellent. Thank you. All right, based on the court's review of the evidence, I do find there's enough evidence to convict Mr. Phillips of this offense. The court will follow the plea agreement in this case. The court convicts him of driving while intoxicated, third or more offense, assesses his punishment at 12 years confinement in the Texas Department of Criminal Justice Institutional Division. Court assesses a $2,000 fine. Court orders $60 in restitution, $15 in reimbursement fees, and orders court costs in the amount of $290. And the court will award Mr. Phillips 119 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Phillips, since you've already been fingerprinted, you are hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Good luck to you, sir.
Thank you, sir.
You're welcome.
That's all I have here, may I be excused here to go to your courtroom for Mr. Watson?
Yes, sir, please.
All right, we'll be over in a minute.
Thank you, ma'am.
I don't know if that's.
You guys are ready and I'll send the court to pick up the other one.
to him, I believe a 2-year extension with safety condition probation.
So what was your final offer?
2-year extension on probation, safety as condition.
Mr. Knoll, have you communicated that to your client?
It was communicated sometime earlier today. Actually, I met with Mr. Watson on Sunday morning. Whether it's clear today, Mr. Watson and I discussed many different scenarios. I told him that I believe, based on my 37 years of doing this, best likely outcome was the possibility of safety, extension. Email or a verbal conversation this morning. My understanding, State's Council met with Ms. Weaver. Up there, she was agreeable to extend probation with safety that would sometimes didn't like that idea. Said it was a higher more case. I'm ready to proceed. We reviewed the 7.
All right, we'll go ahead and go on the record. Mr. Watson, this is CR 17392, State versus Larry Allen Watson. Mr. Watson, will you raise your right hand? Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
All right, you can put your hand down. Mr. Watson, Mr. Knoll has indicated to the court earlier today and then again just now that you're wanting to hire an attorney to represent you. Is that true?
I was wanting to, sir, because he is so rude and the way he spoke to me just belittled me and make me feel very small. I mean, he not kind of me. And that's why I wanted to dismiss him and get another counsel.
But you were going to hire your own attorney?
I would, but I think the best thing for me to do is go with what's up. I don't want to go back to TBC, sir.
Well, let's don't get into that right now. So you may have an opportunity to testify today if that's your choice, but I just need to know if the court should go forward with this hearing with you and Mr. Knoll representing you.
Yes, sir.
Need to know, I asked the state prosecutors what the best offer was, and they've indicated that is their recommendation or offer rather, not recommendation, but their offer was to extend your community supervision and keep you on community supervision, extend it, and recommend substance abuse felony punishment facility. That's a 9 to 12 month program with aftercare at a halfway house. And so that's the offer at this time. Have you considered that offer? And do you feel like you've come to a decision on that?
Was there like a 2 or 3 year sentence for TDC and safety, or was it just one or the other?
State, can you tell me, State, what all offers were in the case? What offers exist right now for Mr. Watson?
As of right now, it's for TBC with whatever back time he has, or we would extend his probation additional 2 years with safety being a condition of that probation. You'd still be on probation, you have to do safety as a condition of that. So you wouldn't go to TDC, you go to safety. And then once you complete that, hopefully you have the skills to complete probation beyond that.
Mr. Knoll?
The only thing I'd say is part of back time, again, this information coming from Mr. Watson, he would have very little, but back on about 44 days, his time was correct. In response to the rudeness, I think what I would have to say is many times defendants find being honest with them as being rude. I don't like wasting my time nor theirs, so I always tell them the truth straight up front. That's why the first time I met with him, based on what I know the allegations to be, that probably best case scenario for them was safety, not just because of this case, but because of what I'd say is a history of back and forth with met issues that are contained as 2 of these 7 counts in the application. But he gets to do whatever he wants to do as far as that. Very high ready. I think the state's ready. He wants to take the 2-year extension with safety, or if he wants to go to 4 years.
Do you believe, Mr. Knoll, that you can still effectively represent Mr. Watson, considering the state, his complaint or his description of what he perceives to be rude behavior? Is that going to prevent you from adequately and zealously
Yes, I
representing?
don't fall in love with any of my clients. What I do is represent them to the best of my ability based on the facts and the law involved. I don't have any young friends. I don't anticipate becoming their friend. I anticipate them in the representing the best of my ability in the facts and the law as they exist. Ready to proceed.
So, Mr. Watson, I guess I just need to hear from you on what you want to do and consider this. We can't wait until the day of our hearing and decide, hey, we want another lawyer. That if we did that, we would never have a trial because someone would always want another lawyer. So I can, but I'm not going to grant you a reset for you to hire an attorney. If that's something that you wanted to do, quite frankly, you should have done that before we got here today. If you want to file a complaint against Mr. Knoll, you're still able to do that at this time after this hearing. But at this time, I've asked the state to provide the offers. And so I need a decision from you. You've got 2 offers on the table, and that's 2 options. And the third option is we have a hearing today, and if the state proves up their case, then the court will have various options to it that Mr. Knoll can argue. If the state does not prove up their case, then that will leave you back on community supervision, my understanding. So do you need a few minutes to think about it, or do you know what you want to do?
But I think when things went, I think the best thing for me to do is sign for it. I'm like, I see the 4, if they give you 3, they give you 3. But if I sign 4, I'll sign 4. I'm shaking inside, I'm not on that for it.
So the state has offered 4 or continue you on probation with drug rehab. You say you're at the mercy of the court. You're not at a sentencing hearing before the court at this time. I just need to know, do you agree with the state? If you don't agree with the state, then we have a hearing, and perhaps I give you more, perhaps I give you less, perhaps I give you the same. I don't know until I hear the evidence.
Sir, what I'm saying is that I'm looking at the best time to get back on my dad. He got to decide with this part, right? I'm scared of losing my dad while I've been here. I'm not disagreeing with the rehabilitation at all. I mean, I got diagnosed, and they gave me my diagnosis of depression and anxiety. And I just don't lose my dad while I've been here. He lost his mom while he was incarcerated. I don't want to deal with it.
I understand, but your actions have led you here today. And so your actions have consequences. And now you get to have at this point of the court proceeding, you have the ability to decide what that consequence is. And so now what is it that you want the court to do? Do you want the court to allow you in the state to do a plea agreement at 4 years? Do you want the court to approve a plea agreement at rehabilitation with a 9 to 12 month program? Or do you want to have a hearing and put on your evidence and let Mr. Knoll have an opportunity to cross-examine the state's evidence, and then let the state and your attorney make arguments as to what each believe is appropriate for you? All right, so Mr. Watson, is this your choice? Is this your voluntary choice? You're making this decision because this is what you want to do? Now, I understand a decision like this is a weighty decision. It has a lot of consequence to it. I understand it's not to be made lightly. So I understand you've got pressure on you, and I understand these decisions are not easy to make, but are you making this decision intelligently? I understand, but it's,
But I believe I'm making the right decision. If I better.
It's the same. If you have the opportunity for the state of Texas to help you with a drug issue that Mr. Watson knows has been a long and ongoing issue off and on for years at no cost to him. I don't know why he did not take that opportunity, but he doesn't have to. Mr. Watson needs to understand that the 4 years, that offense is a quarter-time offense, which could mean as much as a year. It might be less, it might be more. That depends on the Texas Department of Criminal Justice Institutional Division. As he has indicated to the court, he has been to the Texas Department of Criminal Justice Institutional Division before. Therefore, he may do a little more time than normal. He may not make for parole because he has been to the Texas Department of Criminal Justice Institutional Division before. However, I don't make those decisions. State does not, this court does not, but EDC will. Because the opportunity to get drug rehab at zero cost, again, I don't know why it doesn't take. But in he wants the 4 years, the state's got to go second. His problem, not mine. On that.
May I speak?
go ahead. Go ahead. All right, back on the record, CR 17392, State versus Larry Allen Watson. So it's my understanding that the state and the defense and the defendant have reached an agreement for Mr. Watson to plead true in exchange for a recommendation of 3 years confinement, Texas Department of Criminal Justice on a revocation with credit time and balance of financial obligations.
That's our understanding.
Okay, all right, we'll set this matter then for sentencing for the court to accept the plea of true tomorrow afternoon. You want 2 or 2:30?
Stephanie should be able to get paperwork in the morning. I'll meet with him. I think noon is gonna be 12:30 till then jail. So I should be able to have paperwork then and ready to go.
Okay, so we'll just set it at 2 p.m.
Sorry, someone coughed. Did you say
2 p.m.
2 p.m.
2 p.m.
Is that what you said, 2 p.m.?
works for me?
Okay. All right, Mr. Watson, we'll see you back tomorrow afternoon. I will.
And she finally got off. It's sitting on my desk.
I forget what it say.
Basically, you tell me, I told you you were being so hard.
Oh, yeah. Oh,
And
yeah,
she
that's
finally
right.
got one.
That's right. Yeah.
And so she gets, she's just like, you just love to- she just-
That's what
That's what, well, I gave you that opportunity.
That's what
Basically, I helped you.
Forlorn. All those sanctions were. I don't think that you should have been.
It's stuff.
And I got
Can
it
we
done.
not see this like we work hand in hand there? Can we not see this like a teamwork?
No, call me.
Go me.
Go you, Stephanie. Go you. See you, girl.
Thanks, Kurt.
See you, Kurt. Thanks for your patience today, man. I appreciate it. Mr. Back, go ahead. Hey, I'll just tell you right now how I feel about it, okay?
And